Hello and welcome to a recap of our January 30, 2026 newsletter on trademarks, franchises, and other legal stuff. I'm Tom Vanderblumen. I'm a lawyer in South Carolina. We focus our practice on trademarks and franchises and other intellectual property and business matters. It's been pretty chilly here in South Carolina, and there is more snow on the ground still, but our canine law clerk has been having a good time in it. Our last newsletter, we covered Dearest, gentle newsletter reader, the new official season of Bridgerton on Netflix, and what this has to do with trademark law and copyright law. We talked about the well-known gold jackets given to NFL Hall of Famers, and how a recent trademark case mentioned them, and what that has to do with being slack and wearing slacks. We walked through the steps and timeline for a U.S. trademark application. If you like this kind of stuff, you can like and subscribe, and you can sign up for the newsletter in the link in the description. Even if you don't like trademark and franchise law, you may enjoy the occasional pictures of our canine law clerk at work and our regular trivia questions. This week's trivia was about Harold Ramis's masterpiece movie that involved Bill Murray. Bill Murray played the greenskeeper in Caddyshack, and he liked to bomb gophers. But Harold Ramis's movie that we were asking about involves Bill Murray interacting with another rodent. If you think you know the answer, you can send us an email if you want to be considered for the trivia. Bridgerton is back. Does unofficial mean non-infringing? Dearest gentle newsletter reader, I'm not Julie Andrews, so I won't pretend to imitate her voice the way she narrates the show, but you fans of Netflix Bridgerton are probably excited about the start of the new season and seeing what the ton are up to. And by the way, can you believe that Julie Andrews, who played Maria in The Sound of Music in 1965 and was in Mary Poppins the year before, is still getting it done at age 90 today? Anyway, you Bridgerton ton fans, don't get so excited about the new season that you stage your own unofficial Bridgerton musical. Someone tried that a few years ago, and it turned out like you might expect. Queen Charlotte said, thumbs down. It started out just as some fun fan fiction. There is certainly a lot of that for popular shows, and in this case, it started with two women who would post Bridgerton-inspired songs on TikTok. Fans seemed to like it, and Netflix even seemed to tolerate it. My wife has even mentioned that people will have Bridgerton-themed weddings, if you can believe that. But apparently the two TikToking Bridgerton fans crossed the line, at least for Netflix, when they produced a full-blown musical in Washington, D.C., calling it the unofficial Bridgerton musical, casting Broadway actors, charging up to $149 for tickets, and selling merchandise bearing Bridgerton trademarks. They even had a show planned for Royal Albert Hall in London. Netflix sued for copyright and trademark infringement, complaining that the musical copied liberally and nearly identically from Bridgerton. To paraphrase George Costanza, was that wrong? Was it okay to do this, but just call it unofficial? Maybe the defendants had some arguments about being fans, and maybe even some fair use thrown in there, but they probably realized that would be an uphill battle, since they were openly commercializing their event and selling merchandise. The suit was settled soon after filing, according to Variety. Latches, slacks, and gold jackets. Apparently getting a fancy jacket is a thing in pro sports. We all know the green jacket in the Masters golf tournament, and there are other jackets in golf too. There's a red one, even two tournaments that give out plaid jackets. In pro football, inductees to the Hall of Fame get a nice gold jacket. That gold jacket was part of a trademark lawsuit that was just dismissed in Florida. The suit was brought by the heirs of Victor Maitland, a retired advertising executive. He helped transform a loose group of former NFL players called the NFL Alum into a successful charity, and he was involved in developing the gold jackets. Maitland passed away in 2019 at the age of 98. Last year, his estate sued the NFL, however, claiming that the NFL had misappropriated his intellectual property by continuing to use the gold jackets and associated emblems without his permission. Last week, the federal court hearing the case in Florida ruled that too much time had passed since the NFL began using the jackets for Mr. Maitland to complain now. The court explained that the plaintiffs would need to rely on evidence beginning as far as 49 years ago, when Mr. Maitland first joined the NFL Alum. And as the court said, if there were ever a case where improper delay would apply and where defendants would be prejudiced by that delay, this is surely one. You've probably heard about statutes of limitations. That's how long you can wait before you bring a case. But here's a fun fact about the Lanham Act, which is the primary federal trademark statute. It doesn't have a statute of limitations. Now, while some courts look to the most analogous state law for a statute of limitations, courts also apply the equitable doctrine called latches. Latches rhymes with latches like a door latch, even though I was in a hearing one time in Atlanta where a federal judge said it is pronounced lâché with a French accent, which does sound fancier. Latches is the equitable concept that waiting too long to sue will bar the claim if the delay prejudices the other party. For those who really want to nerd out on legal history, back in the day there were courts of law, where you sued for money, and there were courts of equity, where you sued to get a court to force someone to do something or to stop doing something. In the equity courts, where you might not even have a jury, the judges often applied rules of fairness in ways that may not have been allowed in the law cases. And if you're really curious, this is part of why the Seventh Amendment to the Constitution refers to the right to a jury trial in suits at common law. Well, at least in suits at common law involving more than $20. Now that's $1,789, mind you. According to Etem Online, which I think that's how you pronounce it, is an online site about word origins, the historical uses of latches refer to negligence in the performance of a legal duty, or even a slackness, a negligence or want of zeal, coming originally from Latin terms to slacken or relax, and loose, yielding, indulgent. In other words, quote, to be slack or languid. If latches means being slack, that's an interesting coincidence, given that Hager Clothing was one of the co-defendants in the case. Hager is the clothing company that actually makes the gold jackets, and on its website, Hager claims to have coined the phrase slacks in the 1930s as a take on the term leisure time or slack time. The idea is that Hager slacks would be worn during the slack time, away from work. The word slacks is pretty generic now, and referring to pants as slacks, or trousers, may lead to other questions, such as, just how old are you? What is the timeline for applying to register a trademark? We get this question a lot. Here's a breakdown of the key events for filing a trademark application at the U.S. Patent and Trademark Office. There are really 4 main stages that we would like to consider: pre-filing strategy, preparing and filing the application, examination and opposition, and registration and maintenance. First, pre-filing strategy. This is what it sounds like, the strategy before filing an application, and it involves evaluating the options, what kinds of trademarks to file, and whether to do a trademark search, and what kind of search. As for what kinds of trademarks or what trademark you want to file, is it just the words? Like, for example, Nike? Is it just a logo? For example, the swoosh? Or is it a combination where you might have the words and some artwork or a logo? Some of this depends on budget, some of it depends on the marks, some of it depends on what you find in your search. And is the term even distinctive enough to be a trademark? As for a search, are there conflicting marks, meaning confusingly similar marks that are already on the trademark register or that someone else has applied to register before you? What about trademarks that are being used by others that are not registered? Those are sometimes harder to find, but people who have unregistered trademarks can still have rights to oppose your application. This is where you consider the plans for the trademark, including whether you've already used it for a while or if this is a completely new trademark, and how detailed you may want your trademark search to be. How hard would it be to rebrand or change things if a conflict comes up? You can't avoid all conflicts, and no search is perfect. And some conflicts may even come up after the trademark office has approved and registered your trademark. The second step, or the second phase, is preparing and filing the application. Again, it's what it sounds like: preparing, gathering the information you need, and then filing the application. It can be done fairly quickly, assuming you have all that necessary information. This includes making sure you identify the proper owner, which can be a little trickier than you might think, listing the goods and services that are going to be claimed, which can affect the cost of the application and whether you conflict with other marks, and providing evidence and dates of first use for your trademark for certain kinds of applications. Applications are prepared electronically and they're also signed electronically. Some people ask if they should wait to start using the trademark before filing or go ahead and file. It's a good question to discuss, But filing the application before use can be very beneficial in some cases and is usually quicker when it comes to preparation. Another consideration is whether you want to file in other countries, since you may be able to take advantage of your U.S. filing date when filing in other countries. You can file directly in other countries, or in many cases, you can file through a system called the Madrid Protocol, which we always thought sounds like a Jason Bourne movie. The third phase of the application process is examination and opposition. So after you file, you wait. But how long do you wait? The U.S. Trademark Office website says it is now examining applications filed 5 to 6 months ago. We've seen it being longer, up to 10 months. Sometimes it's been as short as 4 months. So let's assume 6 to 10 months before you hear back on your application. This is not, I should add, not like registering your car or for classes in college. It's an actual examination process, and the Trademark Office can refuse your application. The trademark examiner might find the trademark is too close to someone else's trademark that's been registered or previously filed and still pending. The examiner may decide that your trademark is too descriptive or generic to be a trademark, or doesn't function as a trademark, as the terminology goes. The examiner may also require amendments or request additional information about your application. Now, even if the examiner refuses the application, you do have a chance to respond and offer arguments and reasons why the mark should be registered. Now, getting past the examiner is not the only step in the process. Someone else may have a problem with your application and oppose your application when it is published for opposition. Oppositions can sometimes take a while, but often they resolve by agreement. The last step in the process is registration and maintenance. If your application gets through the process, the U.S. Trademark Office will issue a registration certificate. At that point, you can use the R with a circle around it, sometimes called the trademark registration symbol or the circle R that you see next to trademarks. If there are no refusals and no oppositions, the whole process can take less than a year, but usually not much less than that, and often more, especially if the trademark is not being used when the application is filed. To maintain the trademark registration, you do need to submit periodic filings every so many years with proof that you're using the trademark. We'll include a link in the description to the U.S. Trademark Office website that explains that part of the process. If you like this kind of stuff, you can like this video and subscribe to our channel. And you can also sign up for the newsletter in the link in the description. Even if you don't like trademark and franchise law, you can enjoy the occasional pictures of our canine law clerk at work and our regular trivia questions. We hope you enjoy.